Hello, current and future foster parents. Thank you for joining me today. I'm Felicia Nelson, the Executive Director of the Nebraska Foster and Adoptive Parent Association. I have the opportunity and the pleasure to introduce this video, A View from the Bench, a guide for foster parents. This video allows Nebraska judges from across the state to answer the many questions foster parents have regarding court protocol. And I appreciate the Court Improvement Project's efforts in putting it all together. I want to thank you, foster parents, for wanting to make a difference in the life of a child. Being a foster parent is very rewarding, and it allows you to play an important part in the foster care system. In Nebraska, foster parents are welcome to attend the court hearings related to the child that they have in their home. Remember, you're a member of the foster team and working together to help a family. Now, we're fortunate in Nebraska that the judges want to hear from foster parents. They value your perspective, and we all encourage you to complete and submit a caregiver form to the courts. This is your voice in court, a way to inform the judges on how a child or youth is doing and what their needs are. Now, you can find the caregiver form on many sites, but also on the Court Improvement Project's website. Here at Nebraska Foster and Adoptive Parent Association, we are available to answer any questions you have and support you as you're supporting the foster youth and the family. As a previous foster parent myself, I wish I had the information and the insights you are going to hear from the judges today. Now, court can be intimidating. Our hope is that this video will help ease some of your reservations you have about court. So I want to thank the Nebraska judges and the Court Improvement Project for their time and efforts in putting this video together for you.
The courtroom's open to the public. Generally, the foster parents are going to sit back in the gallery. If you have questions or you're concerned about where you should sit, check with any of the attorneys, the guardian ad litem, or the prosecutor. They'll sure help you out with that. And I always tell people, dress like you're coming to court. It doesn't mean you have to be in your Sunday best, but you're not going to the gym either. So just feel comfortable.
When you come to court, you can enter the courtroom and be seated pretty much anywhere in the bench area of the courtroom. You need to be sure cell phones are off. You can wear anything that is decent, I would say. Jeans, shorts, t-shirts, tops, casual, as long as it doesn't have anything inappropriate printed on it and it covers people appropriately. Hearings are public and anyone can appear with a very few exceptions.
Every courtroom is set up just a little bit differently. If the foster parent is making any comments on the record, then we'll have them approach to a microphone so that we can make sure that that's picked up on the record. In terms of what to wear to court, usually business casual attire is appropriate. Just make sure no hats in the courtroom. Make sure that there's no inappropriate language or anything like that on any clothing, but other than that, we're pretty relaxed and groovy when it comes to the attire. Vast majority of juvenile court hearings are open to the public, and so certainly whoever wants to observe the hearings is more than welcome to do so, so you're more than welcome to bring somebody with you.
Well, first of all, foster parents are always welcome in the courtroom. And as a matter of fact, we appreciate them being here for hearings. In terms of protocol, probably the first best thing to remember is to turn your phone off so it doesn't ring during a hearing. That's always a distraction, and actually sometimes I can't hear people speaking if a phone goes off. You sit in the gallery, usually, unless counsel for some reason has invited you to sit with them, then by all means you won't need court permission for that. Counsel gets to make that request, and the court would certainly allow that. And courts are a public forum. So if you would like to bring someone with you, you absolutely can. As a judge, I just request that be somebody who is mature enough or respectful enough that they would protect the privacy of the child. Courts are public, like I said, so there's a public record and there's an order from our hearing, but all the adults involved worked really hard to protect the privacy of a child. So I just ask you to consider that if you want to bring someone with you.
We don't necessarily expect people to dress up for court. Of course, we appreciate it if someone comes and they're neat and they're clean. You can wear better clothes if you want, but jeans are okay in my courtroom, so that's just fine. So it would always be a good idea for you to check ahead of time if you want to bring someone. I mean, obviously a spouse or something is fine, but as far as your neighbor who's interested or curious, that's usually not done. We usually wouldn't want you to bring other people, because probably you should check with the case manager, and if the case manager has questions about whether it's permitted, they will communicate with the court and get permission or get the no that they can't come.
There are, and the foster parent involvement is kind of up to the foster parents to some degree. There are numerous hearings that we have for juvenile cases. The first is the protective custody hearing, and that's the first hearing at which the court determines whether the juveniles or children will stay in out-of-home placement. Usually that's held within 8 days of removal. Then there's a first appearance, and that's the hearing to advise parents of their rights and plea options and to go over the petition and allegations that are made against the parents. Then the next hearing, which may occur at the same time as the first appearance or at a separate date, is the entry of plea, where they either admit or they deny the allegations of the petition. Then we set it for the adjudication, which is a trial on the actual petition that's been filed. And if they are found, or if they're adjudicated, or the petition is found true, then we set it for disposition, which would be the sentencing form in juvenile court. That's the hearing to first set out the orders and conditions which they're going to need to comply with in order to have the child reunified into their home. Then every 6 months at least, we're required to have review hearings where we review the placement, we adopt the court report case plans, we adopt permanency goals, which would be whether they're going to be reunified, a guardianship, an adoption. And then if things are not going well and do not continue to work towards reunification, then we have a termination of parental rights trial.
There's a statute that indicates that foster parents are entitled to notice of any hearings that occur when a child is residing with them. So that could end up being a protective custody hearing, which is the first hearing where parents are advised of their rights, the possible consequences of what will happen, and the court makes a determination as to whether or not the child would continue to remain in protective custody. It could be an adjudication hearing, which is the stage of the process where the allegations of the petition are found true or not. That could be by a plea of admission of the parents, or that could be by trial. You'd also receive notice of a review and permanency planning hearing where the court reviews case progress, or a termination of parental rights hearing.
Normally a foster parent, I don't usually see foster parents in my court, although there's really no prohibition for them to come earlier, but I usually don't see foster parents until we get to disposition or review. Until a case has been adjudicated, I think a lot of times maybe it's just better from a relation standpoint, a standpoint of the foster parent's relationship with the biological parents, maybe that they don't come until after there's been an adjudication. I usually don't see foster parents appear in court until disposition or reviews.
So anytime that a child is placed in a foster home, a foster parent is more than welcome to be present at that hearing. Most of the time it's going to happen on the abuse neglect side, so those are what we refer to as 3A cases with child welfare. And in those types of cases, once the family's been adjudicated, then myself and vast majority of my colleagues will ask the foster parent if they have any comments at any disposition or review hearings at the end of those hearings. And so it's always great to hear from foster parents in terms of any perspective they have of needs of the children or just generally how they're doing. I do have foster parents come on law violation and truancy cases as well if children are placed out of the home there. And again, the same holds true, that it's helpful for me to hear how they're doing and any needs that youth has.
You're welcome to attend any of the hearings. Generally, the way it works in juvenile court is the first hearing is also known as an advisement hearing, and that's where the parents are going to be advised of their rights and the possible dispositions in the case and ramifications. Sometimes there will be an admission or denial by the parents at that hearing. Generally not. Generally, we come back to that. And then we'll also set what's called an adjudication, which is the trial. And then after the adjudication, if the state prevails at that, then the case will move on to disposition, and then we'll have periodic review hearings after that. The foster parents are welcome and encouraged to attend all hearings. There is a caregiver information form that the court sends out to you, and you're not required to return it, but I will tell you as a judge, I find the information very helpful, and if you can, we certainly appreciate you returning it.
So you'll always have the representation of the state, which is generally the county attorney. And then you will have the parents and the parents' attorneys. Sometimes, depending on how many different parents there are and what their interests are, there may be 4 different parents or 3 or 4 different parents, and each one will have an attorney. So there could be quite a few people there. The children's guardian ad litem would normally be present in the courtroom. Other people in the courtroom would be the Department of Health and Human Services case manager. A lot of times different service providers will appear if they've been working with a family. Sometimes there's a HHS supervisor also there, so it can be quite a large crowd in the courtroom. CASA workers are generally there if there's a CASA appointed to the case, so we can easily have 20 people in the courtroom for one juvenile case. So.
You're going to have the prosecutor who's representing the state of Nebraska. You'll have the parents, and they'll appear with their attorneys. Generally, each one of them will have separate attorneys. And then the child, your foster child, also has a guardian ad litem that will be present.
Usually in child welfare hearings, there are lots of attorneys. There are case managers and other case professionals, foster parents, sometimes the children. The attorneys, one represents the state of Nebraska, that's the prosecutor. There may be 1 or 2 of them. Each parent involved in a juvenile case has their own counsel. So depending on the number of parents, you have that number of counsel. The children generally have a guardian ad litem. Sometimes a child may have a guardian ad litem and an attorney appointed to represent them. I have one case where there are 2 guardian ad litems who represent 6 children. And then counsel for the Department of Health and Human Services will also be present.
All right, so you have the judge, obviously, who's hearing the case. You have the county attorney who represents the state. That's who files the petition and is obligated to prove up on the petition. The guardian ad litem is the person that's been appointed by the court to make recommendations and basically do everything that's in the child's best interest. They are the child's advocate. The mother and her attorney, and the father and his attorney, and then usually there's a Department of Health and Human Services caseworker.
So most of the hearings, we are going to have counsel for parents. We're going to have a county attorney. We're going to have guardian ad litem that represents the best interest of the children. We're going to have a representative from the Department of Health and Human Services. On law violation cases, we'd also have probation, and then obviously the judge and court reporter or a courtroom clerk. So the guardian ad litem is an attorney that serves a dual role in representing the best interests of the children as well as advocating for any of the children's needs. And so they do not represent the foster parents, but frequently guardian ad litems will have contact with foster parents, as that is who's seeing the kid from day to day, and it's a good source of information for them. It's open. The vast majority of proceedings in juvenile court are open to the public. I, for myself, love to have foster parents present, and if I'm aware that they're in the courtroom, we'll certainly ask if they've got any comments, if it's the type of hearing that I'm needing those kinds of comments. So, yep, they're always welcome, and I think it's helpful for not only the parties, but also the foster parents to know everybody and see who's interacting with the child and be able to let everybody involved know if there's any needs that the child has. I love to have kids in court when it's appropriate. There's a few hearings that there's adult issues being discussed that are probably not best for smaller ears. But anytime that a juvenile that's on my docket wants to be in court, then we'll certainly make accommodations to have them appear at the hearing. And just like with foster parents, I will go to that juvenile to see if they've got anything they want me to know and any comments that they might have after all the evidence has been submitted as well.
I think foster parents are always welcome in court. I don't think there's any type of hearing that they would be precluded from. Foster children are also encouraged to attend court if they can. We certainly understand sometimes that's not possible. The schools have been very good about allowing their students to appear by video. In my courtroom, we use Zoom. Foster parents are also allowed to appear in that matter. We understand you have lives that you're busy with on your own, work, so sometimes it's just easier under the circumstances to, I call it, Zoom in for a hearing, and you're certainly welcome to.
All right, so foster parents can appear at any hearing. They're public hearings. They may not wish to appear on occasion because the parents are threatening or they don't feel safe around the parents. Children will either be excused by the court or will be required to be here, and that's something the county attorney or guardian ad litem or even the caseworker will let the foster parents know.
As far as the court's concerned, foster parents are always welcome in court, but I think that we hope that maybe the foster parent gives some thought to what the parents' position is at that point, what kind of relationship they may have with the biological parents. It can be counterproductive. For example, if the biological mom, let's say, is very resentful towards the foster parents because she's very angry about the situation at the time. We hope ultimately it gets to a different level, but sometimes initially at least that can be an issue. And although we want to keep foster parents informed and always appreciate their participation, there are times when it can be counterproductive to what we're trying to accomplish with the natural parents, and maybe again, always just having that conversation with the case manager. Do you think it would be a good idea for me to sit this one out, or do you think it's okay to come? I think it would be appropriate. The case manager or the guardian ad litem would be another person that the foster parent could ask to say, is this a good time for me to be in court or not? I welcome kids in court. There are different stages of the proceedings where maybe we're going to be saying some things that would be difficult for a young child to hear about their parent, or maybe if the parent's not being cooperative, that's something that we don't really necessarily want the kids to have to listen to. Also, very young children, if they're under 3 or 4 years of age, court's kind of difficult and boring for them. So again, it's maybe not the best for them to be there because they get nothing out of it, nobody gets anything out of it, and it's just a distraction. So, but certainly if you have an older child that really wants to be at the proceedings, then absolutely give us we like knowing ahead of time, but absolutely bring the child with you.
I cannot think of an occasion when a foster parent wasn't welcome in court. The children are always welcome at a hearing in regard to their life and what's going on in their life. Deciding whether or not to bring them, I think a foster parent would want to ask the child if they want to be there, speak with the child's guardian ad litem about the child being there, particularly if a child's requesting to be there. There's also a nudge for juvenile court judges to start having children attend hearings more than they do here in Nebraska and some other jurisdictions. And so we want to consider the age of the child also. Children who are probably under 7 aren't going to be able to understand what's going on with court and with a hearing. But we're told, research tells us, children beginning about 7 or 8 really do have an interest in what goes on at the hearings. They understand there's a judge, they understand there are hearings, they understand they were removed from home, and that's all they understand. Sometimes they don't even know why. And being able to attend hearings helps them to integrate the information and helps them understand. So children are always welcome. There's just some things to consider when deciding whether or not to bring them.
I've heard, I think, on
I generally refer the people to the guardian ad litem for that. The guardian ad litem represents the best interest of the children. If you don't think the child is getting fair representation, my guess is the guardian ad litem is also having that concern. So that's a good way to address it. And then if the guardian ad litem needs, they can bring it to the court's attention. You can also bring it to the court's attention in your caregiver information form.
I would start with the case manager if you're worried that the guardian ad litem is not sufficiently advocating for the child's right. There's also hopefully a CASA worker involved. Usually with this kind of team approach then, and that's exactly why we appoint the CASA volunteers and have the case managers, is that usually with a team kind of an approach, this can be addressed informally. If it becomes a big issue and a serious issue, the court can be notified either by one of the volunteers or the case manager, and ultimately there is a recourse at the state level with an ombudsman, but I've never had that happen. We're always able to resolve any issues about representation at the court level, and we're able to kind of move on past that.
So there are forms available for foster parents to provide what's called a caregiver information form to the court. And the caregiver information form will give the foster parent, there's some questions on the form for the foster parent to complete, but then there's also space for the foster parent to let the court know about anything else that they feel is relevant. Caregiver information forms often then are offered and marked as evidence, which means everybody involved in the case would get a copy of that and would get to see that before the court would be able to receive that into evidence. Certainly foster parents can reach out to the county attorney involved, they can reach out to the guardian ad litem, they can reach out to the representative of the Department of Health and Human Services. Sometimes there's a CASA involved in the case, they could reach out to them as well. And so it's just a matter of making sure that if there's any concerns, that letting the parties know that what those concerns are, so if they can be addressed, then they can do what they can to address that. I believe it's available on CIP's website. I know that we have it available here in Lancaster County Juvenile Court, and if they contact our front desk or any of the bailiffs, then they can also get that to the foster parent. Departments sometimes will have it available, as will foster care offices in terms of the foster care support worker.
I would first suggest talking with Department of Health and Human Services legal counsel for that case to get that information. Talk with the case manager also, but if you want to talk with people who might be able to advocate for the child in regard to that issue, Department of Health and Human Services legal counsel would be first, but also the prosecutor and also parents counsel.
Probably the best person or persons to speak to would be the caseworker or the county attorney.
It's natural, only human, to be nervous if you're asked to testify. A couple things. First, maybe get with the guardian ad litem or the party that plans on calling you to testify, and ask them if it would be possible for you to go with them to the courtroom so you get a chance to sit in that witness chair before you're actually called to testify. Maybe they can run you through some of the questions just to kind of get that comfort level. It's not easy sitting up there. There's going to be cross-examination. Sometimes whoever's going to call up the foster parent will do a mock of the testimony and take you into the courtroom for that specific purpose. The whole point is to make you feel comfortable, and just remember, you're just telling the truth. There's nothing to hide.
If you're asked to testify at a hearing, hopefully you're just being asked to testify about observations. One thing I think is really important, and it's a really hard thing for most of us to do, is to not give opinions about what we think should happen or what we think is going on there. Even if you have some behavioral health training, you're probably not a psychologist or an expert, so it's important maybe that you don't try to give opinions about the child or the parent or anything like that. What you're probably being asked to testify to are your observations, what you've observed about the child and the child's behaviors, and or interactions between the child and the parent if you have that opportunity to observe that.
The county attorney or the guardian ad litem, whoever's calling you, should go over your questions or testimony prior to trial, just to say, this is what we think we're going to ask you, this is what we think other parties may ask you. It will vary from case to case. Sometimes it's about the child's behavior after a visit. Sometimes it's the contact you have with parents and what's going on there. Sometimes it's simply the child's health or education. So it's a variety of information that may be requested from the foster parents, but someone should go over that with you ahead of time.
So if you are being requested to testify, it's usually going to be a specific party that will be calling you to testify, whether it be the county attorney, guardian ad litem, parent's attorney. I would say then you want to touch base with the attorney that's going to be asking you questions so that you've got a better idea of what it is that they want to hear from you about and what that testimony is going to look like. And then in terms of preparing for the testimony, again, you're going to rely on the attorney that's calling you to testify. I'll say from my perspective, it's important when any witness is testifying that they wait for the entire question to be posed before they answer. Make sure as you're saying yeses and nos, because yeahs and nahs don't show up very well in the record, and just answer the question that's being asked. And then, like I said, the attorneys would all have a chance then to ask any follow-up questions or any other questions as well if you're being called as a witness.
You should be intentional about being in contact with the party that subpoenaed you and ask for preparation time. A subpoena is an order to appear to testify.
You can let counsel for any party and or the caseworker know if you think that there is information that is simply incorrect. Foster parents also provide courts with a caregiver report, and that can include any information you want the court to know.
The caregiver information form that again is available on the CIP's website. The caregiver information form is again will be marked and offered as evidence and will be available to all the parties for review prior to the court receiving that. But that's really a direct avenue then for foster parents to be able to have evidence before the court, and then as I indicated, myself and many of my colleagues will also ask if there's any comments that the foster parent might have as well. I think it's important for foster parents to know though that comments are not considered evidence, that comments are something for the court to consider that's kind of a summation of what the evidence is before the court makes a decision. And so if there's something that needs to be considered as evidence, that should be done in a foster care review form or through testimony versus comments that are made at the end of the hearing.
The court will always ask a foster parent how a child is doing, if there's anything that they want to bring to the attention of the court for purposes of that day, for purposes of that hearing. Those questions will be asked in different forms, but basically that's what the court is asking. And that's the opportunity for a foster parent to speak up about whatever they think is necessary for the court to know that's best for the child.
I think the caregiver report forms are something that are really valuable to the court. Not every foster parent fills them out, and I understand you're busy, you're taking care of kids, so sometimes filling out 10 pages worth of a questionnaire is more than you have time to do. But as a judge, I always read those. I feel like they give me a different glimpse of what's going on than I get from anybody else. So hopefully if you have filled that out, I will see things from your perspective regardless of what else is presented in court. Again though, if you think that that's not enough or you haven't had an opportunity to do that, the guardian ad litem is someone who should be communicating those things to the court. Case manager, a CASA volunteer, all of those people should be consulting with the foster parents and also presenting at least what they think you want represented to the court.
Yeah, I think that's another great way to go through the guardian ad litem, and then also that caregiver information form. On occasion, I've had foster parents write a letter to me. That's probably not the best way to do that because that's called ex parte communication. If something like that does come in and it happens to make it to me and I read it, I have to share that with all of the other parties. So I would not encourage you to write the judge a letter, but talk with the other parties about your concerns, starting with the guardian ad litem. And it may be that the guardian ad litem can talk to you about what was presented. Maybe there was a misunderstanding, but generally between the two of you, you should be able to work that out and take any appropriate action that might be.
I can't imagine a scenario that a foster parent would need their own attorney. For one thing, you don't really have any legal rights as far as the child is concerned at the point that you're a foster parent. So getting a lawyer involved is probably not anything that is going to be of any benefit, even if you are want some info, you want to have some kind of position. You generally wouldn't have any legal standing to participate on any other level than as a foster parent. So I don't think, as long as parental rights are intact, a foster parent would benefit from having their own attorney in juvenile court.
Generally, foster parents do not need an attorney. Their standing in the action is very limited.
Only if you think you need one, though foster parents have very, very limited standing. Their standing is dictated by statute. Foster parents, by statute, have a right to notice of hearings and have a right to be heard. Foster parents are not a party to an action like a parent or the state or the Department of Health and Human Services. So the degree to which a foster parent can participate is limited.
You know, that's a great question. I've never had a foster parent have an attorney. But at some point, if someone's making an accusation against a foster parent, that would be an excellent time to either request a court-appointed attorney or hire your own attorney. I'm not going to say that won't come up. It's very rare, but it is possible.
So foster parents, the law has changed on this in the last few years. Foster parents can certainly hire their own attorney. Whether or not that attorney will be able to take any action in the actual court case itself is a bit of a complicated issue. And certainly an attorney that's well-versed in juvenile court be able to give better advice on that. You certainly have the right to contact an attorney and to talk with an attorney about what your options might be. I will say that it's not typical for the court to appoint an attorney for a foster parent, but that doesn't preclude a foster parent from contacting counsel on their own.
Actually, I think the caregiver reports are great. So if a foster parent goes through the caregiver report and answers the question that's asked, I think the court gets a lot of good information. What to avoid, I think, is information that the foster parent doesn't have first-hand knowledge of. I see that differently as the mentioning the child told me. I think that's okay and kind of part of your role. But otherwise, information that the foster parent has first-hand knowledge of is what is most helpful.
I don't really know if there's anything that should be avoided. I want to know how is the child doing? Are the other parties that are involved in the case, the guardian ad litem, the caseworker, are they having regular contact with you as the foster parent? They should. And if they're not, that's something that needs to be addressed. I also love the pictures of the kids. You can see the child grow up literally in front of you in those pictures. In the cases that tend to last for a year or longer, I want to know how the child's doing, how you feel about that child. Are you willing to make a permanent commitment if that should become necessary? All the information in there is from questions. And if you have something else you think the court needs to know, that's where you can add that into your caregiver information.
I really like hearing what that child is like from the caregiver's perspective. I like to know what that child likes, what that child dislikes, any needs that that child has that are unmet. I like to hear how that child is reacting to different changes in the case. So changes in visitation, changes in overnights, those kinds of things. I think having that child in your home day to day, you're really the best source at this point in time for the day-to-day needs of that child. And it certainly, from my perspective, really gives more life to all the documentation that I get about certain kids in order to have a better idea of what their needs are and what the court can do to help address any unmet needs that they might have.
Pretty much everything that's in the caregiver report is helpful to the court. You're the people that have the eyes on the juveniles. It can provide insight into how the kids are doing in the foster home, the children's general state of mind, the children's feeling about their parents, how school is going, whether there's something they need, whether there's something they want. All of those things are important to the court, and those caregiver reports are very helpful.
Well, much like testifying, what's most helpful to me is just your observations of the kids' behavior. Of course, so I want to know things like their health and what they like to do, what you've observed in your home. If you have any observations about things that they say about, their parents or anything like that, that is helpful. Again, to the extent that, as someone who's emotionally involved with the children, to the extent that you can be objective and not give opinions, but simply state facts and observations, that's what speaks to a judge who's reviewing those things, and that's what will ultimately stick with us as far as what we know is going on with the kids. So.
It should always be possible during a court hearing, but outside of court, no, that's not really possible. Not about a case. If we pass each other in the mall or the grocery store, we can say hello, but not about a case.
Foster parents cannot speak directly to the judge. They can certainly be called as a witness and asked questions by the judge in open court if they're on the stand, but they would not be allowed to come in and simply talk to the judge.
Generally only in the court setting. Again, that's ex parte communication, so it's discouraged. Obviously, I've run into foster parents at Walmart. I certainly say hello. I'm not going to shy away from something like that, and you shouldn't either. But we really can't talk about the case unless we're in court.
In the court setting, any conversations with the court have to be had with all parties present. And so any private conversations are what's called ex parte communication, which are strictly prohibited in this type of situation. I will say if a foster parent were to approach me in the community or outside of a hearing and talk to me about the case, I have to disclose that to all of the parties on the record. And if the communication was of a nature that it's providing information that would affect my decision making, I would also have to recuse myself from the case. And so that's my long-winded way of saying no, that any conversations you want to have with the court need to happen in a formal setting with all parties present, usually on the record.
Not usually in private. I always usually give the foster parents, if they're present in court, an opportunity to tell the court anything they want, but they're going to be saying it in front of every other party, so that has to be kept in mind. Also, Same with any other kind of communication. I've had foster parents write me letters or send me emails, but I can't keep those confidential. Those are something that is going to go to the other parties in the case. So it's not appropriate for the court to have a private conversation with the foster parents. Know that we appreciate, again, everything that you do, but it's not your rights that I have to protect, and it's not your interests that are paramount for me in the case, and so it's not appropriate that I have a private conversation with you. So.
I think that foster parents, while you don't have representation with the guardian ad litem or the department, certainly reach out to those entities if you have any questions. If you have any questions about what's happening in a hearing, any questions about why courts are making certain decisions or why cases are going a certain way. I know when I was in practice, especially as guardian ad litem, I would hear from foster parents all the time and just try to do what I could to help them understand what the court process was, why the law says that the courts need to do a certain thing. If I can understand as a foster parent, that can sometimes get very frustrating. So I just encourage you to reach out to the team, and if you've got questions or concerns, if they're able to address them, then most attorneys will be happy to answer any of those kinds of questions. They just can't provide you legal advice. But there's certain things in juvenile court that we have to do one way or the other, and they'd be able to provide you a little bit more insight into why a court might be doing something that might not make sense from your perspective as a foster parent.
The role of foster parent, I think, is so much more important than we are ever able to articulate. You're responsible for caring for the health, well-being, education of someone else's children. That is a tremendous responsibility, and it is deeply appreciated by the court.
You know, the very best cases that I have had with the best outcomes have been when I've had foster parents who actually are willing to have a relationship with the biological parents and help them be better parents, almost mentor them. Those are the very best cases that I've had, is when I have foster parents who say, we want to see this family reunify. We're going to work with the bio parents and mentor them and be a resource for them. And a lot of them go on after case closure to have continuing relationships. And that's not always possible, and I know that, and it's, you know, it's reality. It's not always possible depending on the situation. But if a foster parent can go into the situation with that kind of open mind and willingness, at least, those are the very best situations that we have. So.
I would like to say thank you. I cannot tell you how much I appreciate the foster parents we have, how hard I know it is, how difficult some of the juveniles they take into their homes are, and yet they still continue to care for them, provide love for them. So just a big thank you.
See how easy it is? Thank you for all you do, foster parents.